Georgetown Law Federal Society. This series is dedicated to Daniel Webster, one of our nation's most revered orators and public servants. Webster relied on the strength of his ideas to advance the American people's liberty and prosperity. He is rightly remembered as the great expounder and defender of our Constitution. Our resolution tonight is, does the 14th Amendment guarantee birthright citizenship to all? As you may know, this issue is appearing in federal litigation across America. Some may even say that these cases are, quote, subject to the jurisdiction of the United States. It is also important to note this debate largely does not cover, but may be brought up, long agreed exceptions to birthright citizenship, such as foreign diplomats or invading armies, focused more on current issues. To debate, we're thrilled to host the outstanding Trent McCotter, a partner with Boyd and Gray, who testified just yesterday for the House Judiciary Subcommittee on the Constitution and limited government on this very issue. We heard he did a great job. In addition, we are honored to welcome the brilliant Professor Ilya Somin, who joined us on short notice to save our debate. He has written extensively on birthright citizenship and, most important, please give him a round of applause here, he is our first debater to return for a second Daniel Webster debate. We're deeply grateful to the Federal Society and to Georgetown Law for making the Daniel Webster debate series a reality. I now recognize our Director of Debates, Ian Stapleton, to introduce these two stellar panelists. Please give them a warm welcome.
Professor Ilya Somin is Professor of Law at George Mason University and the B. Kenneth Simon Chair in Constitutional Studies at the Cato Institute. His research focuses on constitutional law, property law, democratic theory, federalism, and migration rights. In addition to being the author of many scholarly books, Professor Somin's work has appeared in numerous scholarly journals, including the Yale Law Journal, Stanford Law Review, Georgetown Law Journal, and others. He has served as visiting professor at the University of Pennsylvania Law School, and has also been a visiting professor or scholar at the Georgetown University Law Center, as well as several international universities. Before joining the faculty at George Mason, Professor Somin was the John M. Olin Fellow in Law at Northwestern University Law School. He clerked for the Honorable Judge Jerry E. Smith of the U.S. Court of Appeals for the Fifth Circuit, and earned his B.A. summa cum laude at Amherst College, M.A. in political science from Harvard University, and his J.D. from Yale Law School. Trent McCotter is a partner with Boyd and Gray and leads its administrative law practice. He previously served as Deputy Associate Attorney General of the United States and as an Assistant U.S. Attorney. Mr. McCotter is also Director of the Separation of Powers Clinic at Catholic University's Columbus School of Law. Ms. McCotter served as an inaugural clerk to the Honorable Stephen J. Menashe on the U.S. Court of Appeals for the Second Circuit, and also clerked for the Honorable R. Lanier Anderson III on the U.S. Court of Appeals for the 11th Circuit. Mr. McCotter graduated summa cum laude from the University of North Carolina at Chapel Hill with a degree in economics, graduated magna cum laude from the University of North Carolina School of Law, where he received 8 book awards for the highest grade in the class and served as an articles editor on the North Carolina Law Review. And as Brady already mentioned, perhaps most timely for us is that he testified before the House Judiciary Subcommittee on Constitutional and Limited Government on the very subject of birthright citizenship. So without further ado, if we could have one more round of applause for our speakers, I will hand it off to the debaters.
So I guess I'm going first, and thank you to the Georgetown Federal Society for organizing this event, and all of you for coming, and Trent for his contributions. And we're talking about this topic today because of Trump's executive order stripping birthright citizenship from not only children of undocumented immigrants, but even more indefensibly, children of immigrants who are here on perfectly legal but temporary visas of various sorts. If this order were to be upheld, hundreds of thousands of children would be subject to deportation, even though they were born here and know no other country, or in many cases, if they were to be deported, it would be to horrible poverty and oppression. So far, 4 federal courts have struck down this order, though obviously it's going to be appealed to higher level courts and potentially to Supreme Court. Those 4 federal judges, some are Democrat appointed, some are Republican, but they all reached the same conclusion, and for good reason, as I'm about to explain. So Section 1 of the 14th Amendment states that citizenship is given to, quote, those born in the United States and subject to the jurisdiction thereof. And most of this debate, I predict, will be about what is subject to the jurisdiction thereof and what does that mean? And I think my answer is very simple. And it's the one that's been given for 150 years now by federal courts, by Congress, by the executive branch until now. And that is that subject to the jurisdiction thereof simply means that the children in question and their parents are subject to U.S. laws, as undocumented immigrants and people on temporary visas very obviously are. If they commit a crime, they can be prosecuted, civil lawsuits can be brought against them, and so forth. So they're clearly subject to the legal jurisdiction of the United States. And the Supreme Court in 1898 in the Wong Kim Ark case gave precisely this interpretation. It said that birthright citizenship applies to, quote, all children here born of resident aliens, with the exception of children of foreign sovereigns or ministers, those born on foreign public ships, those who are enemies in a hostile occupation of our territory, and members of certain Indian tribes that at that time had exemptions from U.S. jurisdiction in various ways because they lived on reservations under the sovereignty of those tribes. What all those groups have in common is that the U.S. has little or no legal authority over them. This is most obvious in the case of foreign diplomats who have sovereign immunity. Now, there are various counter arguments that people have brought up to this sort of fairly simple and intuitive reading of the amendment. All of them, I think, are bad arguments, and all of them have awful implications if accepted by the courts that go beyond the specific case of children of undocumented immigrants. So the one most commonly given is advanced by John Eastman, notorious for his efforts to rationalize Trump's efforts to overturn the 2020 election. He said jurisdiction doesn't mean just any kind of jurisdiction, but complete jurisdiction of a kind that exists over U.S. citizens, so that they have the right to vote, are subject to military draft and so forth. There's no evidence that this is true, but if it were true, it would have dire implications for the underlying purpose of the 14th Amendment Citizenship Clause. So, of course, the main purpose was to overturn the notorious Dred Scott ruling, which said that Blacks could not be citizens of the United States. And of course, under this complete jurisdiction approach, states and the federal government could prevent Blacks from getting birthright citizenship simply by denying them the right to vote and other aspects of so-called complete jurisdiction, which, by the way, in 1868, when the 14th Amendment was enacted, states could still do because of the fact that the 15th Amendment forbidding racial discrimination with respect to voting rights had not been enacted yet. So this approach, if taken seriously, would negate the underlying purpose of the Citizenship Clause. A second possible argument that we have seen in some of the cases brought up by the federal government is the idea, well, it's not enough that they be subject to U.S. law, they also have to, quote, be domiciled in the U.S. And there's nothing in the text or original meaning of the 14th Amendment which refers to domiciled. But even if there was, it's pretty obvious that undocumented migrants are in fact domiciled in the U.S. They live in the U.S. That is what makes them undocumented migrants, that they're living here, but doing so without legal authorization. And obviously, this is even more obviously true for migrants who are here on temporary visas. If merely living here without some kind of full rights would not be enough, then again, that would strip birthright citizenship potentially from freed slaves and others, and even other Blacks who are not given fully equal rights by the government at the time. Another argument is often raised is, well, this can't apply to illegal migrants because there weren't any illegal migrants at the time in 1868. That is actually not true. There was, in fact, a large population of freed slaves who either themselves had been brought into the United States illegally during the time after 1808 when the federal government banned the slave trade, but their illegal slave trade persisted, or they were the children of people brought in illegally. There were many thousands of such people. In addition, while the federal government had little in the way of migration restrictions, state governments did. So there were certainly people who arrived in violation of state migration restrictions. And I would note the issue of banning or restricting Chinese immigration was very much in the political agenda in the 1860s. So the idea of legal migration was certainly not something that they weren't thinking of. If they had wanted to exclude children of illegal migrants, they could easily have done so, but nothing in the text or the original meaning of the amendment reaches that conclusion. More recently, Randy Burnett, professor here at Georgetown, and Elon Werman have offered the argument that this birthright citizenship only applies to those people who have exchanged allegiance for protection by the government. There are many weaknesses in this argument, such as the fact that nothing like this is anywhere mentioned in the text or the original meaning. But a big weakness is, if taken seriously, it would not grant birthright citizenship to freed slaves. Because, of course, slaves made no agreement with the U.S. somehow to give allegiance for protection. To the contrary, slaves were victims of coercion. They weren't getting any kind of protection. They were getting horrible oppression. And obviously, their children, same thing. So again, this is another argument that, if taken seriously, would defeat the central purpose of the citizenship clause. There are several other problems with this argument that I've outlined in various critiques of it, but I think this is the single biggest one. Finally, there is the argument advanced by a few people that illegal immigrants are on the same plane as people who are invading the United States, and therefore, if children of members of invading armies can be excluded, then children of illegal immigrants can be as well. The obvious response to that is an invasion is an armed attack, like what Vladimir Putin did to Ukraine, despite the fact that the same president who issued this EO now denies that Putin did it. But that's an invasion. When you send your army to cross a border, that's an invasion. Illegal migration, you can think of it what you will. It is not a form of invasion. And if it was, it would have dire implications for other things, even beyond this particular issue of birthright citizenship. The Constitution says that when there's an invasion, state governments can engage in war in response, and even without federal authorization. So they can start a war anytime there is any significant illegal migration. Similarly, it says that the federal government can suspend the writ of habeas corpus when there is an invasion, which in plain English, for those who may not know, that means they can detain people without trial and without filing charges. So it's pretty obvious that mere illegal migration is not an invasion. Rather, an invasion is, as James Madison said, an operation of war. In addition to the legal issues, there are some policy issues involved with birthright citizenship and some moral issues. We can get into them in rebuttal or questions. For now, merely say, I'm not fully enthusiastic about the policy of birthright citizenship. My complaint is not that it's not too exclusionary, it's not that it's too inclusive, that includes many people, but rather that it's too exclusionary. Ideally, people should be allowed to live and work freely without being constrained by limitations of parentage or place of birth, which are ultimately arbitrary constraints that they cannot control, similar to classifications based on race and ethnicity. However, birthright citizenship is better than the currently available alternative, which would be hundreds of thousands of children subject to horrific deportation. And regardless of what the best policy might be, what the Constitution says is that these people are entitled to birthright citizenship, and that the subject to jurisdiction thereof exception only applies to narrow categories of people who really are exempt from the jurisdiction of U.S. law. More can be said, but for now I'll stop, and I look forward to your contribution to the discussion and debate. Thank you.
Thanks, Celia. Thanks for all that. Thanks for inviting me. As you said, I'm Trent McCotter. I testified about this yesterday on the Hill. The questions I got from some of the members were interesting questions. If anyone watched that, I hope you probably didn't, but if any of you did, you'll probably see a little bit of repetition because I have some prepared remarks. So the 14th Amendment confers citizenship on any person who is both born or naturalized in the United States, and second, subject to the jurisdiction thereof. Both of those terms, in my view, are terms of art, meaning they don't mean exactly what you think they might on first blush. So I'll start with the first one just briefly. I know that's not really the issue that we're here to debate, but the born in the United States aspect. Think of someone who's born in Puerto Rico, part of the United States, although it's not literally a state, or born in Guam, Northern Mariana Islands, those sorts of things. So you might think those people are born in the United States, right? Well, every court that's ever addressed it, including the DC Circuit a decade ago, the 10th Circuit 4 years ago, have said, no, that's wrong. Actually, people born in territories are not born in the United States, even though they are obviously born in the United States. So it's one of those technical terms of arts where it doesn't quite mean what you think it might. Now, a lot of those individuals get citizenship by statute instead, and so it usually doesn't come up. There's only a very small group of people who do not. So turning to the second part, the jurisdiction, subject to the jurisdiction thereof. The DC Circuit said, again, this was only 10 years ago, that means not merely subject in some respect or degree to the jurisdiction of the United States, but completely subject to their political jurisdiction, and owing them direct and immediate allegiance. That allegiance term is a historic term, has a nuanced definition. That history is lengthy, complex. I won't be able to cover all of it or even a big part of it today. I did write a brief, an amicus brief that we filed in a couple different courts that gets into it more. But there's three particular aspects about that subject to the jurisdiction thereof and its ties to allegiance that I do want to cover here. So the first is the importance of the Civil Rights Act of 1866. I'm actually going to start with a statute that came just before the 14th Amendment. So there's widespread agreement, I think, that the Citizenship Clause of that 1866 Act and the Citizenship Clause of the 14th Amendment mean the same thing. And you might question, well, why would they have a constitutional amendment for something they just passed a statute on? And there's a couple of reasons, but the main one as relevant here is that President Johnson had vetoed the 1866 Act. It was enacted over his veto. But there are concerns that Congress did not have constitutional authority to enact the 1866 Act. And so they decided to constitutionalize it, to remove all doubt, and also obviously to prevent any future president from trying to change these sorts of principles. And so that's why they essentially did the same thing again in the 14th Amendment. But they didn't use exactly the same language, and that's the important one. The 1866 Act said, citizens are those who are born in the United States and not subject to any foreign power. That's the language there. So my view is that not subject to any foreign power, it's just a negative version of what the 14th Amendment says, which is that the person must be subject to the jurisdiction of the United States. So if someone is subject to a foreign power, a foreign state, then they are not subject to the jurisdiction of the United States. If they have divided loyalty, they're not subject to the jurisdiction of the United States. Dual citizenship was a thing back then, although it was relatively rare. It was viewed very skeptically. It was viewed as dangerous in a sense. A lot of people had the view that you had to be a citizen of one country and one only. And so if you were already a citizen of another country or the subject of another country, you couldn't possibly be a citizen of the United States, let alone subject to the jurisdiction thereof. So Senator John Bingham, who was a principal author later of the 14th Amendment, said that, so what does this term mean? He said, quote, every human being born within the jurisdiction of the United States of parents not owing allegiance to any foreign sovereignty, that's the quote, would be a citizen. I think the way to think about it is birthright citizenship would be reserved for those who at the moment of their birth were not claimed by the parent's home country. So it takes me to my second point, the relevance of the parents. Obviously, the 14th Amendment itself refers to the jurisdiction of the United States over the child. It doesn't mention the parents, but the John Bingham quote just talked about the parents. And a lot of people talk about the parents, even the accepted agreements for children of ambassadors. It is obviously referring to their parent status. The children themselves aren't ambassadors, not typically. And so it still turns, at least in part, on the parents' allegiance, they would say. What's the deal with the parents? And so the reason, the explanation, I think, as to why everyone looks to the parents is because at the time, and often now as well, the parents' home country would claim the child as a citizen regardless of where the child was born. So an example, at the time of the 14th Amendment, English law would say that the child of two English citizens born in America was at birth an English subject. I think what the framers of the 14th Amendment were trying to accomplish was to say that that child would not be entitled to birthright citizenship under United States law because the child is already at the moment of birth subject to the jurisdiction of, I guess at the time, the English king, queen, the English crown at the time, allegiant to Britain, not to the United States. And so that's why there are scholars who've argued now that the crucial inquiry was, quote, the parent's allegiance to a foreign country, end quote. And I think Ilya is right in a sense that like immigration laws back then are nothing like they are now, that the terms that we use are not the same. There weren't the same categories. There were immigrants, obviously, back then. But the point is, like the terminology back then, like whether someone was here legally or not, wasn't something they would have thought about one way or the other, which is part of the reason why people can go through the record and find good support for both positions. They weren't talking about lawful permanent residents. They weren't talking about visa holders, these sorts of things. LPR obviously did not exist. Visas did, although they weren't really the kind of thing they are now. And so that's why the record is obviously pretty strong on both sides, I think. So even today, though, many nations deem the children of their nationals to be themselves nationals of the parent's home country. For example, like the United States is like that. There are a few exceptions. They have carve-outs based on whether parents have resided, that sort of thing. American law at the time of the 14th Amendment did the same thing. The laws of a lot of countries whose migrants are coming to the United States now, it's like Colombia, Nicaragua, Venezuela, Honduras, they have the same thing. The children of two Venezuelans born in the United States will be deemed a Venezuelan national or citizen at the time of birth. So this leads me to a third point, to respond a little more directly, I suppose, to what Professor Soman said. And this is a common argument that subject to the jurisdiction thereof means subject to the laws thereof. But I think the exceptions, the agreed upon exceptions, kind of prove that that can't be right, or at least it's incomplete. So as he said, there's widespread agreement. The children of ambassadors born in the US, children of foreign soldiers, and I don't think he got into this one as much, but at the time especially it was agreed the children of American Indians, or tribal Indians in particular, were also not covered by the Birthright Citizenship Clause. And the explanation commonly given, at least to the ambassadors and soldiers' children, is not really subject to US law. But ambassadors and diplomatic officials have at least only a limited form of immunity. There are very few who are completely immune, and even then, not really, because their home country can rescind it. It can be case by case, person by person. I think an even better example are the foreign soldiers. Foreign soldiers on United States territory, I think, would be subject to American law. You can ask, depending on how you define it, maybe that's in the details, but you can ask the soldiers from, could have asked the soldiers from ex parte wherein, German soldiers who were captured in Long Island, Chicago, Florida, and they were all executed after the Supreme Court authorized them to be subject to trial. Now, granted, it was a court martial, not a civilian trial, but if it's the question of whether they are subject to the laws of the United States, obviously it was the law of the United States that was being applied to them. So those two examples don't seem to fully explain it. The parents don't actually have complete unconditional immunity. There's also, as I said, the example of American Indians. The United States has always had jurisdiction over Indians, at least since the Constitution in its initial form was ratified. There's laws from 1789, 1790 regulating relations with American Indians. But everyone agreed at the time, and I think most people agree now, that the Citizenship Clause does not apply to, at the very least, children of tribal Indians. And the explanation given as to why they would not be is because they still owed at least divided loyalty to their tribes. So you're loyal to your tribe. Maybe you're also in a way loyal to the United States, but remember, it has to be total, it has to be unconditional. You have to be allegiant only to the United States. So I think in that sense, the argument that subject to the jurisdiction thereof means subject to the laws thereof proves too little. In a sense, it could also prove too much. If it's right that ambassadors or foreign soldiers who are maybe like kind of subject to American law, but maybe not fully, if having that kind of contingent or partial immunity were enough to render your children not covered, think about the other groups, domestic officials who have forms of immunity. Prosecutors, judges, I mentioned this yesterday, members of Congress under speech or debate clause have certain forms of immunity. If that were true, that having a contingent or partial form of immunity were enough to mean that you were no longer subject to the jurisdiction of the United States, then your children of congressmen, congresswomen, judges, prosecutors would not be citizens. We know it's wrong, obviously they are. And so what's the reason? The reason is their parents, the members of Congress, judges, prosecutors, they're all loyal, they're all allegiant to the United States. That's the original point that I made today. I think it also would have been quite easy in the 14th Amendment to have just said subject to the laws thereof. The Constitution repeatedly uses this phrase, the laws. The laws refer to things passed by Congress and signed by the president or enacted over his veto. It's a very specific, again, term of art. And so why didn't they use the phrase subject to the laws thereof? I think perhaps they meant something a little different. The 14th Amendment, each one of the separate clauses, Citizenship Clause, Equal Protection, Due Process, they each use slightly different language. And maybe you think it's just like sloppy draftsmanship or something, But I'd like to think, and maybe we kind of have to assume that it was intentional. There's a little bit different language for each one, and that this was on purpose. That shows when they use subject to the jurisdiction thereof, they meant something specific. They meant a very unusual term, a nuanced historical term that's very detailed. Even in other contexts, the Supreme Court has said the word jurisdiction is a word of many meanings, too many meanings. And it shouldn't really be surprising that Congress's use of this word 160 years ago would likewise be very nuanced and difficult to understand. On Wong Kim Ark, it's an opinion that has language that both sides can cite as fully supporting them. Ironically, Wong Kim Ark has another section that says, you shouldn't read all these broad statements in the Supreme Court opinion so broadly. Of course, they didn't heed their own advice. Their opinion talks about all sorts of different things. It's unclear exactly what is the actual bare holding of Wong Kim Ark. A lot of people have argued, a lot of circuit courts have said, because the opinion speaks so broadly, we must construe it in light of its facts. And in light of its facts, the court said that Wong himself was entitled to citizenship because his parents were essentially lawful permanent residents, and they owed allegiance to the United States in the sense that they were allowed to be here and they were permitted to reside here. Now, you could make the argument that, well, even like a lawful permanent resident, the modern equivalent, still has some allegiance to their home country, right? This came up at the hearing yesterday, actually. It's a good point, I think. I think it's an argument that Wong Kim Ark, at least in that sense, maybe went a little too far. It's not entirely consistent with the understanding of allegiance at the time. Doesn't really matter for purposes of this executive order. The executive order carves out lawful permanent residents. And so, like, part of the reason why there seems to be an inconsistency here is because the executive order is trying to follow that historical understanding of allegiance while also obviously trying to follow the Supreme Court's Wong Kim Ark opinion and its kind of sort of narrowed reading. And when you have to deal with Supreme Court opinions, sometimes you end up with some internal inconsistencies. That's just how it is. So, like, what test in the end covers all the groups that we agree on are accepted? I think it's the allegiance test. I've yet to hear a test. This isn't, I'm not trying to be cheeky or anything, but I've yet to hear a test that covers just children of diplomats, foreign soldiers, and American Indians, but nobody else. And I guess if you make the argument that they're not subject to US law, then I would say, I think there are other groups that would be in that category. And so it's difficult on both sides, I think, to come up with a clean test. I don't think there is a perfectly clean test for either side. I think it's a difficult question. Obviously, the courts will resolve it. We'll see. It's sometimes forgotten, although I mentioned it here at the beginning, that Congress always has statutory authority to grant citizenship. They largely have for individuals born in territories. They have for American Indians, which is why those sorts of issues don't really come up anymore. Congress, of course, could pass a statute that makes very clear that the children of immigrants here without permission are indeed citizens at birth. I understand the argument that some people say they're already covered and you don't need a statute to do so. It's obviously correct if that understanding of the Constitution is correct. But Congress could always eliminate any doubt by passing a law. I would suggest that's what they would do if they wanted to. Thanks.
A lot of interesting points, well crafted, but have the same kind of problems as some of the other arguments that I covered previously, namely that if this argument that he just made is correct, it has sweeping, dire implications that go beyond just children of illegal immigrants. Notice that on this theory, even legal immigrants would not be entitled to birthright citizenship for their children, so long as the government of the country to which they came from had a rule of citizenship whereby the children of parents who are citizens become citizens, which most governments, by the way, do have that. Second, it would exclude a large proportion of freed slaves. I mentioned before, a large proportion of freed slaves were either themselves people who had been brought in illegally from other countries, or alternatively, they were the children thereof. And of course, those other countries, African states, or in many cases, by this point, these were areas were part of European colonial empires. Those countries, under their laws, would claim that they are citizens. So if allegiance just arises from the idea that some other government may claim that you are a citizen, then it has that dire implication. The 1866 Civil Rights Act, there is a reason why it uses very different words than the 14th Amendment, and it simply excludes those words that might be construed as making things depend on allegiance or not. And obviously, it certainly excludes that which would prevent granting citizenship to large numbers of freed slaves, including those who are the children of those who had been brought in illegally. So I think this argument would essentially defeat the main purpose of the 14th Amendment. As for the exceptions, the diplomats, the children of members of invading armies and the like, I think it's clear that the issue here is that these people are excluded from the vast majority of ordinary US law. If they're covered at all, it's only because they're covered by some elements of international law and the like. And that's very different from the idea that, say, a member of Congress gets immunity for the things that he or she does on the floor of Congress, but is generally fully subject to civil and criminal lawsuits. And similarly, with government officials like prosecutors have immunity for particular types of acts and the like. There's a difference between somebody who's generally subject to US law, but has some narrow category of immunity, but is not, versus someone who has a general presumption of not being covered, but there are a few unusual situations where they could be covered. And that's particularly true with diplomats, foreign sovereigns, and the like, where in general, the only situations where they could be covered is if their government waived their immunity, which would of course change their status. So I think it's readily clear that, say, if somebody's here as a foreign diplomat, but they lose their diplomatic immunity, but they stay in the US and then they have kids, fine, those kids get birthright citizenship. That I think is fairly clear and intuitive. It is true that Congress can grant citizenship, and I would note that Congress has passed a statute in 1940 that uses the same wording as the 14th Amendment. That statute has always been understood as granting birthright citizenship, including to undocumented immigrants. It's yet another obstacle to the Trump administration's position in this case. But even just under the Constitution, I think the relevant standard is pretty clear that jurisdiction means generally subject to the laws and not something related to allegiance or the like. If allegiance is taken as just a possibility another government can claim you, whether or not you have agreed to give allegiance, then it would exclude most children of legal immigrants, would also exclude a lot of freed slaves. If allegiance means that you've made some kind of deal to give your allegiance to grant it, then of course small children by definition have not done that, and certainly freed slaves had not done that. And so I think either way you get sort of extreme, obviously wrong implications that have to be rejected. Finally, he quoted Bingham. I would note that there are other framers of the amendment who repeatedly said that children of immigrants would be granted citizenship. They specifically raised issues about Chinese, Mongolians, and others. And even though the home governments of those immigrants would claim them as citizens, this came up. And Bingham himself, in another context, said that in a speech he gave while the amendment was being framed, he says, "The word natural born citizen are there, and the man is a natural born fool who does not understand that the term natural born citizen implies that citizenship is a birthright. He comes with a man into the world. He has a right to the citizenship upon the spot in which he had his origin." And notice that there's no exceptions here based on allegiance. So in this other, more famous occasion, Bingham was very clear in stating that this is a general principle that doesn't have some kind of vast sweeping exceptions that would apply to virtually any child of any immigrant, and would also exclude large numbers of freed slaves. So on that I conclude, but I look forward to the further discussion and questions.
I'll start back with the historical record. The historical record, I'll admit, it's kind of like long Mark. You can read it and both sides find the stuff they like what Scalia said about legislative history, right? Like you look over it and find your friends. So I'll point out that Senator Howard, who is, as far as I can tell, he's actually the one who first invoked and proposed the new clause during the debates that became this language, the jurisdiction clause, that all persons born in the United States subject to their jurisdiction thereof. He said, quote, "This will not, of course, include persons born in the United States who are foreigners, aliens who belong to the families of ambassadors or foreign ministers accredited to the government of the United States, but will include every other class of persons. So to the extent do you read that to say that foreigners, aliens, those who belong to families of ambassadors or foreign ministers, there's some debate about how to read exactly what he said, some punctuation debates there, but obviously they were at least aware of the concept that extended beyond just ambassadors and foreign ministers. They had thought of the idea of people who were foreigners, aliens who were here. There was another senator who said, it's perfectly clear that just because you're born here doesn't mean you're entitled to exercise political power. So this is another issue about whether the Equal Protection Clause is has the same scope as the Citizenship Clause. They do use slightly different language. They both say the word jurisdiction. Equal protection refers to those who are within the jurisdiction of a state. Citizenship Clause refers to those subject to the jurisdiction of the United States. Very confusing. When you read the debates, it makes a lot more sense. Jurisdiction, they said, has two senses. There's the jurisdiction, like when you're in a country, you go visit France, for example, you still have to follow the laws of France. You're within their jurisdiction. Just like, and they said in that case, you'd be protected if someone punched you. The person who assailed you would be hopefully charged and be subject to law. It's not as if you're like a non-existent person there. However, that doesn't mean that you become subject to the jurisdiction thereof for purposes of citizenship if you have a child there. So there's two differences, like there are two concepts to the term, and they don't necessarily mean the same thing, even though they both use the word jurisdiction. So that's my response on the historical record. On the children of immigrants who are here illegally, so most common, of course, would be visa holders. Professor Solomon's right. Those are individuals who are here with the consent of the U.S., assuming they haven't overstayed the visa or violated the terms of the visa. But they still don't owe complete allegiance to the United States. Now, as I said, you can make the argument that's true for LPRs too. And I think there's some merit to the argument. The counter response to that is just, well, Wong Kim Ark applied to the equivalent of LPRs, and we have to recognize the Supreme Court opinion at least as that far. And so that's how you end up with LPRs kind of in their own category, which I presume, I don't know, but I presume that's why the executive order carves them out. On the freed slaves, I think the best answer there is that the children of freed slaves would not owe allegiance to foreign countries. They wouldn't owe any allegiance to the home country, whichever country it may have been. Again, the purpose, as Professor Simon said, was to ensure that the children of freed slaves were deemed citizens to overrule Dred Scott. He's right, of course, it would make no sense if the constitutional amendment didn't actually do that. But I think the best answer is that those children, in fact, did not owe allegiance to foreign countries. As to whether the children had to make a deal, I think he's right, they don't. The children aren't saying, I pledge allegiance to my home country of France or Venezuela or whatever. I think it's more an aspect of their parents' home country's law. I think that's the best proxy. I think that's the one that makes the most sense. And so, kind of like with birthright citizenship, let's say for groups of individuals for whom there's no doubt that birthright citizenship applies to them in the United States, they don't really get a choice about it, right? Like you're deemed an American citizen when you're born here. You could later renounce it eventually when you want, I think when you're 18 years old, but you don't really have an option. You're deemed a citizen of the United States. Other countries have very similar laws. And so it makes some sense, I think, that the guys who wrote the 14th Amendment might think, hey, at the very least, maybe some of these people wouldn't want their children to be United States citizens. They're already citizens of the UK or citizens of some other country. And so it makes sense they might carve them out. It sounds like on the exceptions, the children of ambassadors and foreign soldiers, at least, it sounds like there's an agreement that they may not have ultimate, complete, non-contingent immunity. And so it sounds more like it's a debate over how much immunity they've got. I'll admit that consular officials and ambassadors have more immunity than judges or prosecutors, that sort of thing. But at that point, I think we've kind of agreed on the premise, though, which is that the test can't actually be whether you're subject to the laws of the United States. It just turns on a matter of degree then. How subject are you to them? And so I think that's an argument that it kind of falls apart when you try to piece it together too much. I think the only other point is on the statute. Yes, there's a statute, 8 U.S.C. 1401A, that says individuals who are born in the United States and subject to the jurisdiction thereof are entitled to citizenship. It uses the exact same language, word for word, as the 14th Amendment itself. And so I don't think it moves the ball one way or the other. It's just a statute that repeats the Constitution. If the Constitution covers these people, then the statute does too. If the Constitution doesn't, the statute doesn't. I don't think it is a point for either side, to be honest.
questions, ask away.
Professor Silman, in particular, assuming that you think liquidation of constitutional clauses is a good way to figure out the original meaning soon after ratification, so looking at executive practices, how it was interpreted. What do you make of the line of secretaries of state and attorney generals who interpreted a qualified understanding to birthright citizenship? So Hamilton Fish, Grant's Secretary of State, said that personal jurisdiction is a necessary element of citizenship, and Grant's Attorney General, who voted for both 1866 Civil Rights Act and the 14th Amendment, said that the jurisdiction requirement was declaratory of an absolute and complete jurisdiction, such as the United States had over its citizens before the adoption. Chester Alan Arthur, Secretary of State, Grover Cleveland's, Benjamin Harrison's all seem to echo this continued line of a qualified understanding to birthright citizenship, which at least seems to limit the scope of how far it goes.
So I would say during Bill's administration, and indeed every administration up until now, first, birthright citizenship was extended to children of immigrants who could be said to be citizens of their home countries, and also to children of illegal immigrants as well. I'm not sure why he used the term absolute and unqualified, but he clearly did not mean absolute and unqualified in the sense that it excluded anybody who might also, whose parents might also be citizens of another country and the like. Indeed, it is this administration which is going against long periods of unbroken practice and rules. And yeah, to some extent, he's right. You can say there's nobody who's 100% excluded from jurisdiction, perhaps nobody who's 100% included either. But I think it's a big difference between those who are presumptively excluded from most types of jurisdiction and most types of legal constraints versus those who merely have, limited exemptions from certain particular types of laws based on their professional status, sort of like, on the other hand, diplomats, foreign soldiers of an invading army, people on foreign ships, which are under the sovereignty of their home governments, they're presumptively excluded from the vast majority of laws. And while in theory, there might be difficult borderline cases, the case of undocumented immigrants, and for that matter, the case of people here on temporary visas, they're not close borderline cases, they're easy cases because they are in fact subject to the overwhelming majority of laws. And they're at least as subject to them as of freed slaves were, particularly freed slaves who were children of those brought in illegally, which is closely analogous to illegal immigrants. And you cannot, by the way, presume that those people couldn't potentially be claimed as citizens by other countries. So, of course, various African rulers could claim them, European rulers in some cases as well. So, if allegiance just means that a foreign country under their laws might claim you as a citizen, whether or not you want to be a citizen, then lots and lots of freed slaves qualified under that.
If I could, so a similar question came up at the hearing yesterday, and it's essentially pointing out through the late 19th century, there's a lot of discussion from a lot of different scholars about how this concept is nuanced. It's much, depending on how you read it, the exception essentially is much broader than we might today think, but yet for the last 100 years or so, people haven't really made the argument that it's to be construed that way. And so someone asked, one of the members, essentially, how did this happen? At what point did this flip happen to where everyone went from having, I wouldn't say everyone, but most people went from recognizing the clause as carves out more people than you might think, to all of a sudden saying it carves out essentially nobody. And I think the consensus view was Wong Kim Ark in 1898 was the deciding point, because as I said, the opinion has some very broad language. It's a relatively long opinion for the time anyway. And so both sides could cite things. You could walk away after you read Wong Kim Ark very reasonably thinking that essentially everyone born in the United States, with very minor exceptions, would be deemed a citizen, period, end of story. And so I think that's really the point at which things started flipping, because there's lots of evidence before then. Secretaries of State, Attorneys General, treatises, court decisions, like the Supreme Court in Slaughterhouse in 1872 had language that supports this broader view of the exception. And all of a sudden, 1898, I think, is when it all flips. So I think that's how you end up with this period of a lot of evidence on one side and then a longer period afterwards now with a lot of liquidation essentially on the other side.
But I would note, even before one came mark, the general rule was that children of immigrants would get citizenship. There was an attempt to carve that out for Chinese, frankly, because of the extreme anti-Chinese prejudice that existed at the time, rather because of any highfalutin legal argument.
Right, yeah, Mr. McCutter, you kind of gave a bit of a challenge, which was, is there a rule that encompasses both foreign armies and the children of ambassadors and their staff?
And Indians.
And Indian nations, although the word nations might like give a hint there, but like I want to see if I can put one to you and see what you think, because I think Chief Justice Marshall did so in Schooner Exchange, where he said either there's a case of a foreign army, in which case within the territory captured by the foreign army, the United States has no actual power, or it's by consent of the nation. So in the case of ambassadors, and debatable by treaty with Indian nations. This is of course like a fairly old theory as well. Professor Barnett just cited Calvin's case from the 1600s, which is effectively the same thing. Also says that even a child of an enemy alien, if not born within the bounds of a fort captured by the enemy, is born a subject. I'm curious what you make of that test proposed by Marshall.
Well, so if I understand the foreign soldier aspect, the argument is that the foreign soldier on United States territory would not be subject to US law?
In territory captured by that army, but if they go about and commit violations of the civil law elsewhere, then they're subject, which is, I understand it, also a fairly common concept of international law in the 1700s. That areas captured by a foreign power are under the power of that foreign power. Areas not are naturally subject still to the power that controls them.
So a foreign country controlled part of the United States, for example, and then a child was born there, that child would not be subject to the jurisdiction of the United States. And so that's how we get to the exception. But I guess if that were true, the Constitution wouldn't apply at all, and so we wouldn't care about whether the jurisdiction clause applies. I still think like the closest analogy we've got for foreign soldiers would be the ex parte Wherein case. Now, as I said, you can make the argument that they were subject to military tribunals, not to the normal civil courts. And in that sense, you could say they weren't subject to the jurisdiction of the United States, and kind of like the Calvin's case mechanism, like the Calvin case terminology, I mean, which was similar, where someone came into the United States, or they're citing a case, sorry, in Calvin's case, where someone came into the UK, claimed he was the rightful heir of the UK throne, and was captured. And the civil courts in England said, oh, well, we can't try him because our civil courts have no jurisdiction over him. And of course, they then just tried him in like the equivalent of a court martial and executed him. And so the closest we've got, I think, is a case like ex parte Wherein, where you have foreign soldiers captured in the United States, and they're obviously subject to the laws of the United States. Now, maybe not fully in the sense that they were prosecuted in a civil court, but they were subject to some sort of law that allowed for their court martial. The law must have been the United States law under the Constitution. There's no other law that could have been subjected to them that the United States Supreme Court could have upheld. So I think I think the test it's useful to think about like the scope of the foreign soldiers and capture territory and that sort of thing, but I still don't think it gets us all the way there.
So I think on the Querin case, I think that actually doesn't work. Remember, the exception is for foreign soldiers occupying US territory. For those of you who have not read Querin, this dealt with a group of 8, I think, German saboteurs, by the way, 2 of whom were actually US citizens, if I remember correctly, who were clandestinely landed by a German submarine, and then they fanned out to try to engage in espionage and sabotage, but they weren't very competent as they got caught during World War II. Notice at no time were they actually in occupation of US territory. They were really spies rather than soldiers, and they were prosecuted under the laws of war, where soldiers who don civilian dress and try to pretend to be civilians, that's a violation of the laws of war. So that's very different from, like, say, what happened in the War of 1812, where the British Army occupied Washington, D.C. and burned it. There really was a hostile, for a time at least, foreign occupation where U.S. law didn't have control. On the other hand, with the saboteurs in Querin, that was not true at any time. The only way they were out of control is that any criminal might sometimes escape control, where like they're just not detected at the time that they commit their crimes. And so with hostile uniformed soldiers, there's only very limited, if any, control that US law has over them. They're actually occupying US territory, spies, saboteurs, and the like. It's a different story.
From a practical standpoint, assuming this makes its way up to the Supreme Court, what do y'all think happens?
So obviously, my track record of predicting what the Supreme Court will do is not perfect, so I could be wrong, but I think there will not be 5 votes for the administration's position here. And I think there will be a majority. I predict something like maybe 6-3 perhaps for the proposition that the children of undocumented immigrants, and even more obviously, children of people here on temporary visas, are entitled to birthright citizenship. Obviously I could be proven wrong, but I think that's the most likely outcome if it does get to the Supreme Court.
Yeah, I suspect it will eventually. What an interesting aspect of the case is the district courts who have enjoined the executive order, they enjoined it broadly. The government has appealed all of those now, I think except one where they're waiting for a clarification from the district court. But they have not appealed on the merits of it, on whether the executive order is correct under the Constitution. They've appealed only on the scope of relief. They're focusing on whether the injunction should be nationwide, universal, that sort of thing. There's limited to particular plaintiffs, or maybe limited to particular states, that sort of thing. And so I think it will get to the Supreme Court. I think it will probably just take longer than people think it might. People are used to the Supreme Court getting these issues quickly. I suspect that the government's doing this partially it's because you've only got so much space when you do an emergency appeal, but also because I think they want to have a little more time for this issue to kind of like marinate in the lower courts. Now, granted, the lower courts are ruling against them in every instance so far, but I think they want to allow people to like think about it a little bit more, to have, debates like this, that sort of thing, and discuss it rather than like rush up to the Supreme Court as quickly as possible, where I think the professor's right that there's been this understanding for at least, I think we'd agree, probably 100 years by most people that, oh, it just applies really broadly. Almost nobody is carved out from the exception. And people just have that in their mind. And, judges, as much as we might like to think to the contrary, they're going to have that in their mind as opposed to necessarily like what was the understanding 160 years ago. It would be a major shift in the understanding of an important aspect of constitutional law. And so I think it'll be an uphill battle for the government. I don't know what the outcome would be in the end. I think he's right that the votes could shift. You could see votes just saying the executive order period is unconstitutional. You could see votes saying, well, actually, if it applies to this group, it's unconstitutional, but maybe not to this other group, and that sort of thing. It really just depends on how the government presents it. And as of now, they haven't even presented those arguments to the circuit courts.
Dennis, you want to take the last one and then we'll go to closing?
Yeah, sure. Just to kind of like flesh out your point, you do subscribe, Mr. McCotter, you subscribe to the allegiance for protection kind of theory of jurisdictions in a way.
So I think that the best reading of the meaning of it was allegiance. And that's kind of it. Like the reciprocity part, I think comes in. I think there's a little bit of that in the record, but I think it is more of having to deal with Wong Kim Ark, because Wong Kim Ark is the one that ties allegiance. They mention allegiance a lot of times in the opinion, but they also talk about, hey, the Wong's parents are allowed to be here. They're essentially permanent residents, and that's a relevant and important factor. And so you say, well, why does that matter? Like, aren't they still in some way allegiant to China? And it's like, well, but because they're allowed to be here permanently, like we'll deem them to be sufficiently allegiant to the United States. But we can only do that when the United States government says you're allowed to be here. And so you end up having to like mush the two together, where there's an allegiance, but also this reciprocal relationship. And I think that's having to deal with Wong Kim Ark as opposed to like the best reading from 1868. But yeah, sorry.
The reason I wanted to ask was, do you believe people here for asylum claims, do you think they would in some way be swearing effective allegiance to the United States? They do have a child while they're here on a claim. Do you believe that under your theory, they would be that child will be a citizen?
So I think that came up, I wouldn't say it came up directly, but there's a line, and I think it's Elk from 1884 that talks about this, where they say that like the way that an immigrant from a foreign state would become a citizen is to formally renounce the old allegiance, which you might say that an asylum seeker is. Like I'm not going back there. I renounce it. But it also says that the United States must accept that through such form of naturalization as may be required by law. And I was referring to people who are not the ones literally being born here, but to the people who have already been born elsewhere and are coming in. But I think it's a similar concept. It's those groups of people are like visa holders in a sense. Like I think they trigger one of the requirements, but maybe not all of them. Like visa holders are allowed to be here under Wong Kim Ark. That's a very important relevant factor, but they don't necessarily have exclusive allegiance to the United States. They almost certainly don't. That's why they have to have a visa. Similarly, people with asylum claims, like they maybe are allowed to be here. It depends, I suppose, on the current law at the time. Maybe they've renounced allegiance to their home country, but it's not entirely clear that they actually have the full consent of the United States if they have not yet renounced formally renounced it and it's been accepted by the United States. So yeah, I mean, there are categories like that where, as I said, I could easily see the courts, when they have more time to kind of think through this, it's not an emergency basis, saying the executive order as applied to, it carves out LPRs, so we won't talk to them, but as applied to visa holders, doesn't make sense to apply to them, even though you could say there's historical evidence to the contrary. For asylum seekers who are here legally, that sort of thing, you know, can't apply to them. You could even see an argument, I think, getting into like the domicile argument, which I haven't studied it. I wouldn't say I advocate for it or don't advocate for it, but I could see an argument that aliens who are here unlawfully, but who have indicated an intent to remain here permanently, that they essentially have devoted like sufficient allegiance to count. It's kind of like, you know, in the Constitution, there's the term the people, and the people is seen as a term of art. It's not just anyone who's here. Like not everyone who immediately crosses the border has a right to firearms with the Second Amendment or speech under the First Amendment, that kind of thing. They say it's people who have been here long enough to be kind of incorporated into the polity are the people. I could see the court coming up with that. I don't think there's like support for that necessarily in any of the historical documents or even, I mean, maybe you could read that from Wong Kim Ark, but it is like a practical rule in a sense that it would cover most aliens who are here unlawfully, but not the ones who come right across the border. There's another option, getting back to the very, very first point I made. Remember the in the United States language and how in the United States doesn't mean what you might think it does, at least according to the courts. There's an argument, and some courts say this as well, that aliens who come into the country immediately and are detained, some of them are sent back immediately, but some are paroled into the country. Some are essentially allowed to be here, but are deemed not lawfully present in any way, just because you don't want to have to deal with sending them back. A lot of courts have said those people are not to be treated as literally being in the United States. Now, it's not for citizenship purposes, it's for other purposes, but there could also be an argument there that those individuals, ones who come right across the border, just temporarily, they are not actually in the United States. So like everyone's focusing on subject to the jurisdiction, but you could also say maybe the way you capture those individuals who just come here temporarily or right across the border, they're not actually in the United States, even though they are literally in the United States. You can say it's illogical, but the cases all say like the territories aren't in the United States, even though they're obviously in the United States. Yeah.
So I would say that those are stupid cases interpreting the terms in a stupid way, and they shouldn't be extended to other things. I would add also that this idea of full consent, if taken seriously, would exclude large numbers of freed slaves and their children because of the fact that there were many who were brought in illegally after the United States banned the slave trade. So Justice Scalia generally said that the Constitution should be interpreted in accordance with its ordinary meaning in the United States, meanings in the United States, unless there's some overwhelming evidence that it means something else. And the same thing with subject to jurisdiction, which generally means subject generally to U.S. law.
Closing statements? If you have them, if not, we can close here and that's great too.
I can do it if you want to do one. It's up to you, whether you want to have them or not.
I don't have anything else.
Let's wrap it there. All right.
All right. I think we covered